Hi everyone, in this week's dispatch video we are examining a case which has gone before the Employment Appeals Tribunal. It's a misconduct case and it involves the range of reasonable responses test. So as part of the test for unfair dismissal, we have to have a fair reason and we have to have a fair procedure. The tribunal then has to make an objective assessment at the end of that, assuming that both of those parts of the test have been satisfied. And the tribunal must decide whether or not the decision to dismiss in a misconduct case falls within the range of reasonable responses open to a reasonable employer. Now, in this case, the matter concerned dismissal as a result of a joke which was posted on a new work-based platform. The employee posted a joke which contained a number of racist remarks, which obviously he thought would be funny. The post was reported within a matter of minutes and was removed by the IT department. As soon as that complaint reached the employee who posted the comment, he gave profuse apologies, maintained that he did not realise that the post was racist, and asked for some retraining on equality and diversity matters. The chair of the disciplinary hearing stated that the company had a zero tolerance policy towards discriminatory language. And whilst the officer did take account of the employee's long service and unblemished record and the remorse that he showed, he found that the remark was so inconsistent with the company's EDI policy that the only outcome should be dismissal. The employee brought a claim before the Employment Tribunal. They decided that the dismissal was outside the band of reasonable responses, so it wasn't a reasonable and proportionate decision to terminate his employment based on their assessment of the case, which I think I found quite surprising given the language that was actually contained in the post. So the tribunal said that he did offer sincere apologies, he wanted to undergo training, he demonstrated the impact and his insight into the impact of his actions. He did not, the tribunal believe the joke was racist. He didn't understand why. But he did make attempts not to repeat that behaviour. He had unblemished long service with the company, and he had not read the equality, diversity and inclusion policy, which the tribunal didn't suggest was his fault. The tribunal also placed a lot of weight on the fact that the joke was in a context which it wasn't suggested was offensive, so there was no intention to provide a victim or to offend anybody in particular as part of that, and it was just misjudged. The employer, unsurprisingly, appealed to the Employment Appeals Tribunal, and the upshot of the case, once it reached the EAT, was that the tribunal had substituted its own view. So they made a number of remarks in the judgment which suggested that they felt the decision was too harsh, but they didn't apply the objective test, so they didn't put themselves in the shoes of a reasonable employer and say what would that reasonable employer have done. They criticised a number of findings that the disciplining officer made and a number of judgments that they made, and did not substitute that view for one of a reasonable employer. Now, the EAT suggested that the fact the company could have imposed a lesser sanction, such as a final written warning, did not mean that the decision was outside the range of reasonable responses. It didn't analyse the disciplining officer's thought process, but simply imposed their own reflections on their decision that they would have come to. The comments relating to the EDI policy were not relevant because it only transpired at tribunal that the policy had not been read, so that couldn't be taken into account as the employer didn't realise that at the point of dismissal. And essentially the tribunal had allowed its decision to be influenced by the judge's own view of the gravity of the conduct against the mitigating factors which clearly they had some sympathy with. The conclusion of the Employment Appeals Tribunal was that the dismissal perhaps was harsh. They might think that decision, but it was open to them to allow the dismissal as fair based on the band of reasonable responses test. And it's a useful reminder, one, of the assessment which should take place from the tribunals, and not the comfort, but the understanding that the employer has that there is a wide spectrum of responses which can be given in relation to misconduct, and as long as the decision falls objectively within that range, a tribunal cannot substitute its own view, however critical they are of that decision. The second impact of this decision really focuses on this zero tolerance policy. Now, in this case, the employer had a zero tolerance policy towards discriminatory language, and thankfully for them, the EAT agreed that the behaviour was so serious that it did justify utilising that policy. But there was a lot of criticism about an automatic trigger response of dismissal in circumstances where a business has a zero tolerance approach. Essentially, you still have to do the groundwork and analyse whether the decision to dismiss is reasonable in the circumstances, even if something infringes what we say is a zero tolerance policy or approach. So I hope you found that examination of the case law helpful. If you do need any further assistance in relation to this or any other employment law matter, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.